Chapter 10, Spousal Support. After reading this chapter, you should be able to define spousal support and describe how it has evolved, distinguish between spousal support and property division, identify various types of spousal support, identify the kinds of factors courts consider when making spousal support determinations, list at least 5 terms a spousal support provision in a separation agreement should contain, explain when and how spousal support awards can be modified, terminated, and enforced. Identify the primary tax and bankruptcy implications of spousal support and describe the role of the paralegal in a spousal support case. So first off, define spousal support and describe how it has evolved. What is spousal support? Spousal support is an allowance for support and maintenance that one spouse may be ordered by a court to pay to the other spouse while they are divorced or living apart. Spousal support is also called alimony, maintenance, or separate support depending on the circumstances. How has spousal support evolved? Under common law, judges could order husbands to provide for an innocent wife after a marriage ended based on an assumption that she lacked the ability to provide for herself. Since the onset of no-fault divorce and the revision of property division laws allowing women to be awarded an equal or equitable share of marital property, alimony awards have decreased significantly in number. Today, it's estimated that the frequency of alimony awards granted upon divorce is only 10 to 15%. The purpose of alimony is no longer to punish an obligor or to reward an innocent spouse. The purpose of alimony today is usually to enable a dependent spouse to develop skills, enter or re-enter the workforce, and become self-sufficient in a relatively short period of time. Since the Orr decision in 1979, alimony is gender neutral, meaning either party may be ordered to pay spousal support to the other spouse. What are the differences between alimony and property division? Alimony originated in the common law where the common law recognized the duty of a husband to support his wife. Focuses on what each party will need going forward into the future, is based on one party's need and the other party's ability to pay, along with other factors laid out in statutes and case law. So it is not strictly need-based. There are a number of other factors and considerations the court looks at. Requires personal jurisdiction over the defendant who must receive proper notice. Usually involves payments made on a periodic basis, usually payable over a period of time, and payments vest as they fall due. Usually modifiable based on a material change of circumstances, tax deductible to the payor and income to the payee. Generally not dischargeable in bankruptcy. It usually is terminated by death except for arrearages. Arrearages do not terminate upon death. So if the payor dies, then the estate can continue to be held liable. So sometimes you will see a provision where a payor spouse is required to maintain a policy, an insurance policy for securing payment of any spousal support obligation should the payor die prior to the termination of the spousal support obligation. And if the payee dies, then the estate is entitled to receive the spousal support payments. Unless there is a terminating event that is specified in the agreement. Typically, those terminating events are going to be the death, remarriage, or cohabitation of the death of either party, the remarriage or cohabitation of the payee spouse. So those are typically, in most spousal support cases, 99% of spousal support cases are going to have a provision that provide those terminating events. Usually terminates on the recipient's remarriage, absent a statute, order, or agreement to the contrary. No longer primarily punitive, though some courts consider misconduct during the marriage, especially economic misconduct. Property division, on the other hand, evolved with no-fault divorce and a view of marriage as a partnership. At the time of divorce, they look back to identify assets and liabilities that should be divided. It's based on the concept that both parties contributed to the marriage and that marital property should be divided upon divorce according to equitable distribution or community property principles. The court needs personal jurisdiction over the parties and the property to be divided. Property division usually involves transfers of property at the time of the divorce. Property divisions are effective and rights to property vest as of the date of the divorce and are enforceable against the other party's estate as a debt. Absent fraud, property division is rarely modifiable. Transfers of property upon divorce are not taxable events. Property division settlements in the nature of spousal support usually are not dischargeable in bankruptcy. Property division is not affected by the death or remarriage of a party. Some states still consider serious marital fault, especially economic misconduct in property division context. In Ohio, if there is significant economic misconduct, oftentimes the courts will consider what they call a distributive award, which the courts will determine what an equitable distribution would be and then give the innocent spouse a larger portion of the property division to compensate for the financial misconduct of the other party. All right, identify the various types of spousal support. There are 7 most common types of alimony or spousal support. One is temporary alimony or alimony pendent light, interim alimony ordered by the court pending an action for divorce or separation in which a party has made a claim for alimony. So there's going to be temporary support awards in most divorce cases where the courts will award some amount of temporary child and spousal support, if applicable, to maintain the status quo, to keep bills paid, to keep people in their homes, etc. Permanent traditional alimony. Alimony usually payable in weekly or monthly payments, either indefinitely or until a time or circumstance stated in a court order. Term alimony. Alimony payable in weekly or monthly payments for a specified period of time. Rehabilitative or transitional alimony. Alimony considered necessary to assist a divorced person in acquiring the education or training required to find employment outside the home or to re-enter the labor force. Restitution or reimbursement alimony is alimony designed to repay a spouse who during the marriage made financial contributions that directly enhanced the earning capacity of the other spouse. These are going to be circumstances where one party supported the other party while they obtained an advanced degree of law license, medical license, things like that. Separate maintenance, an amount paid by one married person to the other for support if they are not divorced but are no longer living together as husband and wife. And lump sum alimony or alimony in gross, which is alimony in the form of a single indefinite sum and usually not subject to modification. Identify the kinds of factors courts consider when making spousal support determinations. The authority to award alimony is statutory, and although few states have formulas, courts in most states are guided by a series of factors laid out in statutes for consideration. The threshold question is, does one of the parties have a need for financial support that the other party has the ability to pay? Other factors often considered include the following: the financial resources of the parties, including earned and unearned income of each party, the parties' respective liabilities, the relative current and future earning capacities of the parties, contribution of each party as homemaker, the age of the parties, the length of the marriage, the standard of living during the marriage, the health of each party, the tax consequences of the property division, property brought to the marriage by either party, and contribution of either party to appreciation of the marital estate and or to the increased earning power of the other party. If you look at the spousal support statute for the state of Ohio, those are going to be some of the highlighted factors that the courts look at, not highlighted factors, but some of the more common factors that the courts look to in determination of spousal support awards in the state of Ohio. List at least 5 terms a spousal support provision in a separation agreement should contain. Should all contain the goal of the alimony, although it's not necessarily stated. Typically in our agreements we don't state the goal of the alimony, but if it's for something such as, spousal support payable for a term of 4 years for the payee spouse to obtain an advanced degree, something like that. Designation of the payments as alimony, it needs to be specified that it is payable as and for spousal support. The amount, the duration, the frequency and timing of payments. So is it paid once a month, twice a month? Usually you're looking at once a month as being the frequency. The duration can be usually for a term of years. In most courts, the general rule of thumb is that it's 1 year of spousal support for every 3 to 4 years of marriage. But again, there is no set formula. And when you've got really long-term marriages, there are a lot of courts that still will consider permanent awards of spousal support for really long-term marriages. Form of payments, modification, whether the court will or will not retain jurisdiction to modify all or a portion of the spousal support award. Sometimes the court will retain jurisdiction as to term but not to amount, or as to amount but not to term. If there is not a specific reservation of jurisdiction to modify the award, typically the courts cannot award or cannot modify a spousal support award in Ohio. Healthcare insurance, security for payments. Like I had stated previously, sometimes there will be security in the form of an insurance policy or something else to secure payment should a payor spouse die prior to the termination of the award. Survival or merger of the alimony provision. Explain when and how spousal support awards can be modified, terminated, and enforced. If permanent or term alimony was awarded in the party's decree, most states allow a party to file a later complaint or petition for modification based on a material change in circumstances. Absent an agreement, extraordinary circumstances, or extreme hardship, a lump sum, rehabilitative, or restitution alimony award may not be modifiable. The decision to modify alimony is made on a case-by-case basis and is driven by statute, court order, case law, and/or the language of a premarital or separation agreement of the parties. Parties will be held to their agreements absent extraordinary circumstances. The burden of proof rests on the parties seeking the modification. There are no fixed rules for what constitutes a sufficient material change in circumstances. Again, it's a case-by-case determination. Examples of potential sufficient changes, if they have occurred in good faith, often include things such as a forced early retirement or unemployment, the onset of a serious medical condition, cohabitation of the recipient with someone who assumes responsibility for many of his or her living expenses, a windfall increase in income or assets of either party. Again, most of these, not most of these, a lot of these things are going to be provided for in the provision that states when the court would have jurisdiction, or there will be a specific terminating event provision in most separation agreements. Unless otherwise provided in a decree or based on its nature as alimony in gross, an alimony obligation will usually terminate upon the earliest to occur of the following events: the death of the recipient, unless the parties' agreement provides otherwise, the death of the payor, unless it states otherwise, expiration of a stated period of time, the remarriage of the recipient. Again, death is a tricky one. Most separation agreements are going to provide that it terminates upon the death of either party. That's going to be the majority circumstance. If it is, well, I don't want to overcomplicate the issue. If it is a typical spousal support case, it's going to terminate upon the death of either party. Unless otherwise provided in a decree or based on its nature as alimony in gross, an alimony obligation will usually terminate upon the earliest to occur of the following events: cohabitation of the recipient with another. The parties' agreement may specify conditions such as the length and nature of the cohabitation and whether or not the cohabitant contributes to the recipient's living expenses. Cohabitation is a big issue in spousal support cases because there's no really clear definition of what constitutes cohabitation. It used to be that we would specify cohabitation with an unrelated adult male. Now we just typically will utilize the term cohabitation, and the courts have to decide what constitutes cohabitation. Is it just living with someone? Can it be a same-sex partner? Does it require that there be some sharing of expenses? Does it not require a sharing of expenses? Cohabitation is a big issue with respect to spousal support cases. A condition specified in the parties' agreement, such as completion of a particular education program or recovery from a serious illness. How are alimony awards enforced? In most jurisdictions, the primary enforcement vehicle for non-payment of alimony is a contempt action, civil or criminal. Civil contempt is a sanction for failure to obey a court order issued for another's benefit. The action is remedial in nature and is designed to promote compliance with the order. If the defendant is found in civil contempt, the court usually will order payment of the overdue alimony amount according to a schedule tailored to the obligor's ability to pay. In most jurisdictions, the primary enforcement vehicle, again, is contempt. Civil contempt, although the court can impose a jail sentence for an indefinite period to compel payment, the defendant is usually given the chance to pay the arrearage and purge the contempt, especially if there was an inability to pay or the arrearage was the plaintiff's fault. Criminal contempt. Criminal contempt is a punishment for failure to comply with a court order. The proceeding is punitive in nature and is designed to punish an attack on the integrity of the court. The court may impose a jail sentence for a fixed period, and the contempt cannot be purged by payment. Additional enforcement methods include the following. If the alimony recipient is also receiving child support, he or she can seek assistance from the state's 40 agency and its arsenal of enforcement measures, including income withholding and tax refund intercepts. This is one of the primary reasons why we like to run our spousal support awards through CSEA as well, because they've got the backing and resources to pursue payment. In some circumstances, the recipient may seek to place a lien on property owned by a defendant found in contempt. If the obligor dies while the arrearage still exists, the recipient can file a claim against the obligor's estate if payment was not otherwise secured by an agreement of the parties or an order of the court. So again, this is where the insurance policies will come into play. If there's an arrearage due and owing on a spousal support obligation, those provisions that we sometimes add in requiring that they provide a policy of insurance to cover any unpaid portions of the spousal support or any arrearages. That's where those orders come into play and will pay even though the payor spouse is deceased. Identify the primary tax and bankruptcy implications of spousal support. Under federal and state tax laws, alimony is deductible from gross income by the payor and income to the payee if certain conditions are met. If the payments are made incident to a divorce decree or separation agreement, if the parties do not file a joint tax return for the period when the payments are made. Again, if you recall, if you are married for even one day in a calendar year, you have the ability to file a joint tax return. So there are situations, it's quite frequent, where there are situations where you'll have spousal support paid in a year in which the parties technically have the ability to file and it may be most financially beneficial to them to file a joint tax return. The parties are not living in the same household. The payments are made in cash and not in kind. The payor has no liability for payments after death. The payment is not improperly disguised as child support, and the parties have not designated the payments as non-includable in the recipient's income. Under the alimony recapture rule, the government or the IRS can recover a tax benefit, such as the prior claiming of a deduction for payment of alimony by taxing the income it finds no longer qualifies for the benefit. There is no hard and fast rule regarding what can be discharged in bankruptcy. However, the general rule is that domestic relations obligations in the nature of alimony, maintenance, or support are not dischargeable in bankruptcy. Describe the role of the paralegal in a spousal support case. Some of the most important tasks commonly performed by paralegals in spousal support cases include the following: researching applicable governing laws, statutes, court rules, and case laws, gathering information relevant in spousal support cases, drafting discovery requests with particular attention to the factors courts consider when making decisions about spousal support, drafting spousal support provisions for inclusion in separation agreements, and helping prepare for trial by drafting documents, designing exhibits, and assembling trial and exhibit notebooks.